Welcome back to the deep dive. We're here to give you that shortcut to being well-informed, and today we are tackling a massive shift in UK law. A truly fundamental change in how a marriage legally ends in England and Wales.
It's absolutely monumental. We're talking about the Dissolution and Separation Act 2020. We'll just call it the DDSA. And this wasn't some minor tweak. It's easily the biggest change to divorce law since 1969.
So our mission today is to really unpack that whole journey for you. How on earth did we get from a legal system that actually required blame, that forced you to point fingers, to one that's now based on a simple notification?
And crucially, what are the unexpected conflicts that are still there? The new system was meant to get rid of acrimony, but it's created some very high-stakes logistical problems.
Right. It sounds like this whole story really starts with, a bad law that kind of institutionalized dishonesty.
That's a perfect way to put it.
But okay, let's start there with the old system. This was all governed by the Matrimonial Causes Act from 1973. So before 2022, you could only get a divorce if a court agreed your marriage had, and this is the legal term, irretrievably broken down.
Right. That was the one and only ground for divorce. But here's the catch. You couldn't just say it was broken.
You had to prove it.
You had to prove it using one of 5 specific legal facts. And that right there immediately set people up as adversaries from day one.
So what were these 5 facts? How did they, manufacture that conflict?
Well, they were split into 2 camps, really. You had the separation facts, which were all about waiting. You could be separated for 2 years, but you needed your partner's consent.
And if they didn't consent?
Then you had to wait 5 years. 5 years of living apart.
Wow. Okay, so what was the alternative, the faster route?
The faster route involved the 3 fault-based facts, the ones that were pretty corrosive.
The ones that forced the acrimony.
Precisely. They were adultery, desertions, so being left for at least 2 years. And then the big one, the most common and by far the most problematic, unreasonable behavior.
But the second you file for unreasonable behavior, you're basically declaring a legal fight, aren't you?
Absolutely. And because of the long waits for the other options, this became the procedural shortcut. The statistics are pretty stark. Back in 2017, something like 58% of all divorces were fault-based, and unreasonable behavior alone made up almost half of all divorce petitions.
And here's the really wild part. The law demanded you prove this fault, but everyone sort of knew it was often a complete charade.
It was institutionalized dishonesty. Research showed that 27%, over a quarter of couples who used a fault-based reason, later admitted the allegation just wasn't true.
So they were lying to the court.
They were using it as the easiest, quickest option to get out of a marriage that was already over. They were legally forced to accuse their partner of something, even if they'd agreed amicably to separate.
So if the lawyers, the judges, if everyone knew this was happening, how did the system justify it for so long?
It couldn't in the end. Sir James Munby, who was the top family judge at the time, he was very blunt about it. He said the old law was based on hypocrisy and lack of intellectual honesty.
Wow.
Yeah, and he famously called the modern behavior petition little more than a charade. The law demanded conflict, even when none existed.
And if that hypocrisy wasn't enough, one specific case came along that just shattered the whole illusion. It proved the system was completely broken by trapping someone in a dead marriage because they couldn't find enough blame.
You're talking about Owens v. Owens.
Exactly.
That case is, it's totally synonymous with the need for this reform. It ran through the courts between 2016 and 2018. Mrs. Owens, she applied for a divorce. She cited her husband's unreasonable behavior, things like being critical, being moody, just describing a deeply unhappy marriage.
Okay, sounds pretty standard.
But the crucial thing was, Mr. Owens decided to contest it. He defended the petition.
And what did the court say?
They refused her divorce. The family court, then the Court of Appeal, and then all the way up to the Supreme Court, they all said no.
But why, if the marriage was clearly over?
And that's the point. The judge even said the marriage had broken down. But legally, Mrs. Owens hadn't proven that her husband's behavior was so bad that she couldn't reasonably be expected to live with him. The legal bar was just so much higher than anyone realized. Being unpleasant wasn't enough. The court needed serious, demonstrable fault.
So she was forced to stay married? That must have caused a huge public outcry.
It did. It was the final, undeniable proof that the law was just not fit for purpose. And you can tell the judges themselves were uneasy with it. Lord Wilson called the verdict troubling, but they were very clear. Their job was just to interpret the law Parliament gave them. They couldn't change it.
And that was the signal to Parliament.
That was the final push, the political green light for reform.
Which brings us to the new world, the Divorce, Dissolution and Separation Act 2020. It finally came into force in April 2022. So what's the one single change that just completely dismantled that old blame game?
Simplicity. The ground for divorce is still irretrievable breakdown, but now all you need to confirm that is a statement.
Just a statement.
Just a statement. The applicant, or now you can even apply jointly, just provides a declaration saying the marriage is over. That's it. It completely removes the need to find fault, to prove adultery or unreasonable behavior. No more manufactured conflict.
That sounds so much more civilized. And I hear they also changed all the language, got rid of the old Latin terms.
Yes, thank goodness. The old jargon is gone. A petition is now an application. The decree nisi, that first stage, is now a conditional order. And the decree absolute, the final document, is now just the final order. Much clearer for everyone.
And critically, you can't really contest the divorce itself anymore, so you can't be trapped like Mrs. Owens was.
Correct. That's a massive change. You can't meaningfully contest the fact that the marriage is broken down, except on a few tiny technical grounds like jurisdiction. The law now just accepts that if one person says it's over, it's over.
So, okay, the grounds for divorce are simpler now. But what about the clock? The actual procedure? I get the feeling that's where the new complications are hiding.
That's exactly it.
Yeah.
The DDSA brought in this mandatory timeline, a minimum of 26 weeks from start to finish.
26 weeks, okay.
And that timeline is broken down. So first, you have a minimum 20-week reflection period. That runs from the moment the application is issued by the court right up until you can ask for the conditional order.
20 weeks to reflect, and then?
Then there's the familiar minimum 6-week wait between getting that conditional order and being able to apply for the final order that actually ends the marriage.
So 20 weeks mandatory reflection, then 6 weeks for the final paperwork. The idea is obviously to stop people rushing, encourage them to sort things out constructively. But this is where we hit that big controversy, isn't it? The service loophole.
Well, this is where all the tension has shifted.
Yeah.
The problem is that the 20-week reflection clock, it starts ticking the second the application is issued by the court.
Issued. Not when the other person actually gets the papers and finds out about it.
Exactly. Not when they are served. And that gap is the whole loophole.
Wait, so the rules say you're supposed to serve the papers within 28 days. But what happens if you don't? Does the clock reset?
It doesn't, and that's the flaw. An applicant can start the process, get the application issued, and then just sit on it. They could wait 16, even 18 weeks before serving the papers on their spouse.
So your partner would only have a couple of weeks' notice that they're getting divorced before that first big deadline arrives.
Precisely.
That's huge. I mean, theoretically, one spouse could start the divorce, carry on with normal family life, say nothing for 4 or 5 months, all while knowing that clock is ticking down, and then spring it on the other person.
It completely undermines the whole non-confrontational spirit of the act. It can create enormous hostility.
Why would someone do that? What are the sort of tactful reasons?
Well, lawyers have pointed out a few. It could be to give your spouse less time to start their own proceedings in another country if there's a dispute over that. Or, unfortunately, it can just be used to cause maximum distress.
And what about the biggest reason? The one with the most financial risk?
That's the one. Delaying service can be a tactic to try and delay the start of financial claims. And what that does is it dramatically increases the risk that the final order, the end of the marriage, is granted before the finances are sorted out, before a pension sharing order is in place. And that vulnerability is the critical flaw in this new timeline.
So the DDSA solved the problem of conflict over fault, but it's accidentally created this new battleground over timing and financial exposure.
That's the perfect summary. The focus has just shifted from moral arguments to logistical manipulation of the legal timeline.
And since that timing is now a potential weapon, we have to look at what's really at stake here. The money, the division of assets, that's still handled under the old 1973 Act, right?
That's right. The court's main goal, under what's called the Section 25 criteria, is to get to a fair outcome. Now, it's really important for you to know that fair doesn't just mean 50-50.
No.
No. The law says the court's number one consideration has to be the welfare of any children under 18. After that, they look at everything: needs, contributions, how long the marriage was to reach that fair result.
So what tools do they use to get there?
Well, the main ones are maintenance. So child maintenance and spousal maintenance. Spousal maintenance is often just transitional to help someone get back on their feet. The goal is often a clean break. But the biggest asset in so many marriages after the house is the pension.
And if the final order gets rushed through because of that loophole, what is the specific danger with pensions?
The danger is enormous, especially for the financially weaker person, which is often the woman in a long marriage. If one partner dies after that final order is granted, the surviving ex-spouse loses their automatic right to any death benefits from that person's pension or their life insurance policies.
So you need an order in place
You
first.
absolutely need a legally binding pension sharing order, which actually moves a percentage of one person's pension pot into a new fund for the other. Without that financial order being rubber-stamped by the court before the marriage legally ends, all that protection is just gone.
Just quickly, what if a couple wants to sort their finances, but maybe for religious reasons, they don't want to actually get divorced and have that final order?
They can get what's called a judicial separation. It's a formal court process. It settles all the money and the arrangements for the children, but legally, you stay married. It's not common, but it's an important option for some people.
Okay, finally, let's look at the reaction to this whole reform. It had huge support from judges, from family lawyer groups like Resolution. What was their main argument for it?
It was pragmatic, really. They argued it reduces conflict, it cuts down on litigation, and most of all, it just made the law reflect reality. It stopped forcing people to lie about why their marriage was over. They saw it as vital for helping people co-parent constructively after they separate.
But there was some firm opposition, too, from groups like the Coalition for Marriage. What was their primary objection?
Their argument was more about the institution itself. They felt no fault, divorce undermines marriage, and they worried it would lead to a spike in divorce rates. And crucially, they argued it was unfair to the person who wanted to stay married, the one who'd been faithful to their vows, because they'd have no way to even defend against a divorce being started.
Did we have any examples from other countries to look at?
We did, a great one right next door. Scotland. Scotland brought in reforms back in 2006, which really reduced the separation periods, and the data from there is very telling. Now, only about 5% of Scottish divorces are on fault-based grounds at all. It just shows that when you give people a practical, blame-free option, they take it.
So after this deep dive, the main takeaway seems pretty clear. The DDSA 2020 was a huge success in ending that whole era of manufactured conflict. The blame game is over.
It is. The principle is sound. But the implementation, particularly that loophole around the 20-week period and when you serve the papers, it's created a new kind of injustice. It risks real financial harm, especially to the person who has served with the papers late in the day. The fight has just moved from morality to logistics.
Which leaves us with a final provocative thought for you to take away. The goal of this whole reform was to help couples move on constructively. So you have to ask yourself, is just removing blame enough? Or should the law go one step further and actually mandate that full financial protection, like a pension sharing order, has to be finalized before that final legal tie can be severed, to make sure that everyone gets a truly and financially constructive clean break?